In Beckwith versus Dahl, after a bereaved man lost his inheritance to his partner's sister, he petitioned the court to recognize a new kind of tort that would give him a better chance at recovering some of the property. Brent Beckwith and Marc MacGinnis had been in a long-term committed relationship for 10 years. They were business partners and shared a lease on an apartment. MacGinnis had only one living relative, his sister Susan Dahl. They were estranged. One day, MacGinnis showed Beckwith a will that he'd drafted on his computer. This will stated that when MacGinnis died, his estate was to be divided between Beckwith and Dahl. MacGinnis never printed the will or signed it. MacGinnis's health began to decline. While he was in the hospital awaiting surgery, MacGinnis asked Beckwith to print out the will so he could sign it. Before Beckwith brought the will to MacGinnis in the hospital, he called Dahl to discuss it. Dahl replied that it would be better to create a trust to avoid probate. Under this trust, the house and property would be in both her name and Beckwith's. Dahl promised to call attorney friends that night to create the trust. Accordingly, Beckwith didn't show MacGinnis the will he'd created. After surgery, MacGinnis died intestate. He left behind an estate worth over $1 million. Dahl opened probate and applied to become administrator of the estate without naming Beckwith as an interested party. After some months of ignoring Beckwith, she told him the court declared that MacGinnis's assets would go to her as his only surviving family member. Beckwith filed a petition opposing Dahl's petition for final distribution of the estate. The probate judge found that Beckwith had no standing and no intestate rights. Beckwith sued Dahl, alleging intentional interference with an expected inheritance and deceit by false promises. The court ruled that California didn't recognize the tort of intentional interference and dismissed the case. Beckwith appealed to the California Court of Appeal.